to introduce my good friend Carol Handler, who I can't thank enough for her indefatigable efforts this year in organizing. She did everything to make tonight possible, along with Irina Rodriguez from my firm. I actually did nothing except sit and read all their emails. So I'm going to turn it over to Carol, whose thanks I just can't express enough of.
So, and I want to thank Lauren, who made the concept of these lectures come back to life, and the New York City Bar for getting behind it. It's just a wonderful thing for the bar and for everyone to have the opportunity to hear scholars like Professor Hovenkamp. No subject today fascinates antitrust scholars as much as the way in which two legal systems, antitrust and intellectual property, impact innovation and competition. And no one has more brilliantly illuminated the intersection of these two areas of the law and how they might best be applied in a global and technological antitrust universe than tonight's Milton Handler speaker, Professor Herbert Hovenkamp, the Ben and Dorothy Willey Professor of Law at the University of Iowa College of Law. The superlatives used to describe Professor Hovenkamp are very well known to this audience, but I really enjoy repeating them, and I hope it doesn't embarrass him too much to hear them repeated, as they will be. He has been called deservedly the most influential antitrust scholar of our generation. Indeed, he is probably the most cited antitrust scholar alive. His books and articles have been cited in the Supreme Court's eight most recent antitrust decisions, evoking a statement from Justice Breyer, which really says it all, that practitioners would prefer to have 2 paragraphs of a Hovenkamp treatise on their side than 3 courts of appeal or 4 Supreme Court justices. And he is probably the most prolific writer on antitrust since the scholars for whom these lectures are named, with works ranging from the 20-volume treatise started by Professors Arita and Turner to a brand new and most impressive 10-chapter casebook on innovation and competition policy, which I'm actually using in the course that I teach at USC, and which is a wonderful new slant on the subject, to multiple articles on tonight's subject and almost any other antitrust subject one can name. Indeed, if you check the Social Science Research Network, which lists all of his articles and most major scholarship, you will find at least 2 or 3 new significant articles by Professor Hovenkamp every month. And one of the most interesting is a truly almost a revolutionary article written with his wife and colleague at Iowa Law School, Christina Bohannon, called IP and Antitrust, Reformation and Harm, which focuses, among other things, on reforms of copyright and patent law, and so as to protect innovation, subjects that I know we're going to hear about tonight. And meanwhile, to end this list of literary accomplishments, his antitrust casebook remains the bestseller in the field. But there are other reasons that Professor Hovenkamp is the right speaker in this series at this time. His scholarship is probably more than any other scholar very much, and I hope he takes this as the compliment, I mean it, in the Milton Handler tradition, for 5 reasons. First, his intellectual curiosity and enthusiasm and love of his subject shine forth on every page of his multiple writings. Second, in 2008, he was honored with the Sherman Award by the Justice Department, and Professor Handler actually received it the year he died in 1998, so they share that well-deserved honor. Third, they both shared an interest in the constitutionally based IP and the way in which that relates to antitrust. That is in some of my father's earliest writings. Of course, the issues in 1924 and 25 were very different from what they are today. Fourth, Professor Hovenkamp is an extraordinarily lucid writer, as I think you all know. He takes the most complex antitrust questions and makes them highly recognizable and accessible so that you think, yes, that's exactly the way it is when you read what he has to say. And finally, the tradition of this lecture series, which I'm told began in the 1940s, has always been that antitrust changes with society, and Professor Hovenkamp, more than any other scholar today, is illuminating the paths that need to be taken so that it remains current in the new global technological world that we live in. So it's really an enormous privilege to have him here. We're very appreciative, and Professor Hovenkamp, please take it away.
Well, thank you, Carol, for those flattering and almost entirely undeserved words, and to the City Bar of New York, to Lauren. I really appreciate the wonderful hospitality and management that led up to this lecture. This is actually my third Handler lecture. I was here once before in 1988 and a second time in 2003. This time, unlike the previous two, I'm going to talk about some issues that lie at the intersection of antitrust law and innovation policy. Managing innovation requires a fusion of policies taken from different legal disciplines, including but hardly limited to intellectual property and antitrust law. This evening, I want to discuss three areas where I believe antitrust has something useful to contribute to innovation policy. The first concerns the relationship between innovation and market structure. Second is a lesson that IP law can learn from the severe revision and remedial doctrine that antitrust has developed in order to align private antitrust enforcement with antitrust law's underlying goals. The third concerns the way the antitrust law should deal with deficient intellectual property rules. Both competition and innovation are highly sensitive to market structure. Markets tend to force prices closer to cost when they have a large number of sellers, but economies of scale may limit how small, efficient firms can be. A vast literature discusses the relationship between market structure and market competitiveness, or the relevance of market structure for evaluating competitive practices. Today, the consensus is quite strong that in the past we gave market structure more importance than it deserved. Nevertheless, structural queries remain essential in order to identify realistic threats to competition. A vast literature is also concerned with the relationship between market structure and the rate of innovation. This literature suggests, for example, that patenting works much better in some markets than in others. In some, trade secrets or simple first mover advantages are better. The optimal length of a patent or copyright can vary considerably from one market to another, even though the actual length does not. The rate of innovation also varies with the number of firms. One pair of authors has concluded that there's probably more empirical literature on the relation between innovation and market structure than on any field in industrial organization economics. One would not know it, however, by looking at patent or copyright cases, or even at the IP statutes themselves. While structural issues play a major role in antitrust policy, they are largely irrelevant to IP policy. The grandparent of innovation policy in the United States was Joseph Schumpeter, the Austrian-born German immigrant who taught economics at Harvard during the 1930s and 40s. Schumpeter is well known for two quite different theories about innovation. Schumpeter's first theory was that innovation contributes far more to economic growth than does competition under constant technology. That is to say, moving a market to more competitive performance while holding technology constant certainly produces gains, but these gains are nothing like the ones that can be obtained from technological innovation. Looking at his own profession, Schumpeter lamented that neoclassical economics had developed theories of imperfect competition, monopolistic competition, and ruinous competition leading to monopoly or collusion, all of which deviated sharply from the classical trust in markets. One reading this literature would conclude that markets under industrialization had become much less competitive in comparison with some, quote, entirely imaginary golden age of perfect competition. In fact, however, the standard of living measured by hours of labor per unit of goods had risen dramatically during the very time that economic theory was becoming so pessimistic. Fundamentally, Schumpeter's views were a critique of what had been happening in neoclassical economics through the first half of the 20th century. The obsession with equilibrium, demand curves, pricing, and competitive strategy tended to see firms as buyers and sellers. Efficiency meant largely productive efficiency in the sense of eliminating needless steps. The theory of monopoly focused on output and price under constant technology. Even product differentiation was regarded mainly as a bad thing because it prevented prices from moving all the way to marginal cost. What all of this ignored, argued Schumpeter, was the truly immense contribution that innovation had made to economic growth and the standard of living. Today, the consensus is clear that innovation contributes much more to economic growth than does competitive operation in an economy where technology does not change. Schumpeter's second theory has to do with the relationship between market structure and innovation. Schumpeter argued that dominant firms are more likely innovators than firms in competitively structured markets. First, he said, monopolists have the resources to fund research and development and are typically in a stronger position to raise outside capital. Further, because of their market-dominating position, the monopolist has less to fear from copying by rivals. Writing roughly a generation later, Kenneth Arrow took sharp issue with almost every one of Schumpeter's arguments. On the appropriation question, the intellectual property laws should substitute for market dominance as a device for protecting the fruits of innovation. Second, small firms have everything to gain if they innovate aggressively and much to lose if they do not. Third, when the dominant firm innovates, it tends to stay in the path it has already established for itself, lest it lose the value of its previous investment. By contrast, smaller rivals are in a better position to profit by upending old technology. As a result, truly radical innovations are more likely to come from small outsiders. The monopoly versus competition debate over innovation has revolved around two issues. First, what is the relationship between overall industry structure and the rate of innovation? Here, the dominant answer seems to be that the innovation curve is an inverted U, with the highest rates of innovation occurring in moderately concentrated markets, but tapering off as the market becomes more monopolized or more competitive. The second issue is, where can we expect the most interesting innovations to come from, larger firms or smaller rivals? The answer here is less conclusive, but it is certainly important. Larger established firms have heavy investments in their own technology, so they are more likely to innovate within an established path. By contrast, the newcomer has less invested and thus a wider array of directions in which its innovations can go. One illustration of this is the heroic efforts that AT&T made during its regulated monopoly period to protect its wired position from the divergent wireless technologies of rivals. Another is the efforts by Microsoft in the 1990s to prevent the evolution of internet-based technologies that threaten Microsoft's established model. Today, important parts of United States antitrust policy tend to side with Arrow on this debate, I believe correctly. For example, the 2010 merger guidelines express a strong concern about larger firms acquiring and eliminating highly innovative small firms in order either to capture or shut down their innovation efforts. The relationship between market structure and innovation raises one perplexing question. Why is structure so important in antitrust analysis and almost completely ignored in the law of intellectual property rights? Very likely, the main reason is that the IP laws were established long before modern concerns about market structure emerged, which was mainly in the early 20th century. By contrast, antitrust policy developed simultaneously with these concerns and expressly incorporated them at a fairly early stage. Antitrust law has always been viewed as a mechanism for assessing and controlling competition. However, the promotion of innovation is much less central to intellectual property law than the promotion of price competition is to antitrust. Rather, the IP statutes in most of the case law have tended to view IP as a set of property rights, which are absolute in the sense that they are largely invariant to market structure or market-specific incentives to innovate. Relatively few decisions assess a particular doctrine in IP against the theoretical or empirical accountings of the impact on innovation. Indeed, in the area of copyright law, the Supreme Court has largely read the innovation incentivizing preface to the Constitution's intellectual property clause out of the document. It has permitted both retroactive copyright extension and even the retroactive granting of copyrights to works that were never under United States copyright to begin with. Such decisions cannot be squared with the limitation on the Constitution's grant of the intellectual property power that it be reasonably calculated, quote, to promote the progress of science and useful art. The outcome of the Schumpeter-Arrow debate can have also other important consequences for antitrust policy. If one believes that most important innovation comes from dominant firms, then the role of antitrust should be fairly modest. Dominant firms typically do not need very much protection from the antitrust laws, and most of their innovation conduct is presumably unilateral. Further, smaller rivals are less deserving of antitrust protection as long as we believe that they are mainly free riders or copyists. By contrast, if Arrow is correct and groundbreaking innovations are more likely to come from small firms, then antitrust has a much bigger role to play. First, larger firms with entrenched investments to defend are more likely to use exclusionary practices, and these practices may amount to restraints on innovation. Second, innovations from smaller firms are more likely to be collaborative rather than unilateral. On my second point, over years of litigation, antitrust has learned that devising good substantive rules is very difficult. To say that courts are not good at quantifying market power or assessing the overall economic effects of a practice is a serious understatement. One thing the Supreme Court has done, however, is put goals ahead of substance by examining the nature of the plaintiff's harm. For example, analyzing the impact of the vertical merger in the Brunswick case, in which a supplier of bowling equipment acquired a struggling bowling alley in Pueblo, Colorado, could be extremely difficult. Over the last half-century, antitrust policy has waffled between extreme hostility and extreme tolerance of vertical mergers. But the plaintiff in the Brunswick case was a competing bowling alley, and the theory of its complaint was that Brunswick was going to rejuvenate the acquired alley, thus increasing the amount of bowling competition in Pueblo. Once it is understood that the nature of the plaintiff's injury was increased rather than decreased competition, it was easy for the court to dismiss the complaint without getting knotted up in the intricacies of market definition and vertical merger law. It is not antitrust purpose to prevent markets from becoming more competitive. That holding was an apparent violation of the explicit provision of Section 4 of the Clayton Act, which gives a damages action to any person who shall be injured. Given the constitutional purpose of the patent and copyright laws to promote innovation, a goal that is stated much more explicitly than Congress's very general power to regulate commerce, which empowers antitrust, the same thing should apply with even more force to IP. Analyzing the impact of a particular IP practice or accused infringement or on innovation is generally far more difficult than analyzing impacts on ordinary price competition. So IP law should require a more potent theory of harm. For private plaintiffs, the analogy between antitrust and intellectual property is strong. Many antitrust lawsuits are brought by private plaintiffs, but even more patent and copyright infringement suits are. Private antitrust plaintiffs do not sue in order to promote competition, but rather to protect their own interests. Consumers are preferred plaintiffs, competitors are always suspect. By the same token, in intellectual property law, the plaintiffs are rights holders protecting their own property interest. One could say the same thing about IP that then Professor Frank Easterbrook once said about predatory pricing cases. The action should be given to consumers rather than competitors. In fact, the law should not be pushed that far, and it never has been for antitrust law. Nevertheless, just as the interests of consumers in antitrust cases are most consistently aligned with greater competition, so too the interests of consumers in IP cases are most consistently aligned with the promotion of innovation, at least when the consumers themselves are not the infringers, something that occurs almost exclusively in copyright. The antitrust injury doctrine helps to ensure that private plaintiffs' interests in antitrust cases are more aligned with those of consumers. IP law needs an equivalent doctrine that will do the same thing for patent and copyright infringement. For all of the attacks on private antitrust enforcement, the fact is that strong links exist between antitrust damages and competitive harm. We condemn properly defined antitrust violations because they cause higher consumer prices and also the deadweight loss that results from reduced output. The effects of IP infringements are very different, however. In the short run, nearly all infringing activities increase output, and thus are at least presumptively increasing of economic welfare. One can posit some situations where the IP owner is a monopolist and the infringer makes a perfect copy, perhaps by pirating a digital work. In that case, one might say that each sale of the infringer reduces by one the sales of the rights holder. In the much more common cases where the rights holder is not a monopolist or the infringer is making an imperfect copy, then infringements virtually always result in output increases. Indeed, often the rights holder cannot show any loss of output at all, but only the non-payment of a license fee, which again is a pure wealth transfer. In some cases, such as infringing derivative works, where the goods in question are complements, sales of the infringing work may actually increase sales of the protected work. In that case, the infringement is a pure Pareto improvement. That is what happened in the case of Dan Brown's best-selling novel, The Da Vinci Code. Brown acknowledged in his preface that he had borrowed some ideas from a well-done nonfiction book by Michael Biagent, Richard Lee, and Henry Lincoln entitled Holy Blood, Holy Grail, which had explored the history of the idea that Jesus Christ and Mary Magdalene had once had a romantic relationship. That legend was a well-established heresy in the Catholic Church. In response to the publicity attending the Da Vinci Code, sales of Holy Blood increased many-fold, briefly putting the book on the British bestseller list. Nevertheless, the publisher brought a copyright infringement action, which was ultimately dismissed because Brown may have taken some ideas, but not expressions. Do output increases entail that IP infringements actually increase rather than reduce economic welfare? No, but it means that infringement remedies are justified only if we look beyond the short run and consider their impact on the incentive to innovate. If a rights holder cannot show that the type of harm it suffered would reasonably have deterred it from innovating the protected idea or expression in question, then the rights holder has not shown any social harm whatsoever. In the short run, welfare is increased by the increased output, and in the long run, the incentive to innovate is not reduced. Indeed, in the case of complements, the infringement can actually increase the incentive to innovate. For example, the authors of Holy Blood would very likely have been more rather than less likely to write their book if they knew that someday some of its ideas would be subject to a blockbuster novel that acknowledged their work. One problem that reformation of this nature confronts is that thanks to years of special interest capture, the IP laws provide quite explicit measures for damages. For example, copyright damages can be measured by the infringer's gains rather than the producer's losses, thus making it possible for a rights owner to sue even though it has not been injured at all. Copyright also provides for statutory damages measures that require no proof of harm of any kind. The relevant issue, however, is not how damages should be measured, but whether the plaintiff is entitled to damages at all. That is, A court concerned about innovation should graft onto the damages provisions a requirement that before the plaintiff is entitled to damages, it must show the appropriate kind of harm, which is objectively measurable loss of the incentive to innovate. If the entitlement to recovery is established with sufficient rigor, then the amount of damages is relatively less important. The Clayton Act damage provision is extremely broad, providing treble damages to, quote, any person who shall be injured in his business or property by reason of anything forbidden in the antitrust laws. Brunswick did little to change the way in which damages are measured, and the historically used measures of overcharges for consumers or lost profits for rivals remain largely intact. Rather, Brunswick created an additional requirement nowhere mentioned in the statute that the harm in question must be not merely injury in fact, but injury to competition. On my third point, a question worth considering is whether the scope of IP protection should vary with the industry. For example, longer periods for durable products such as pharmaceuticals and chemicals, shorter periods for more ephemeral technologies such as electronics and information systems. The regulatory costs of administering such a system would be extraordinarily high. What we largely have developed instead, however, is a second best solution of permitting private contracting to yield industry-specific protections. This has occurred through a remarkable array of devices, including patent pooling and cross-licensing, blanket licensing in digital industries, standard setting and interconnection protocols, and open source provisions. In many cases, these devices represent a private mechanism to contract around intellectual property rights that have become excessive or inappropriate to the needs at hand. Further, the form of these contractual workarounds varies considerably with the nature of the technology and the structure of the market at issue. Because these systems are private, they are for the most part not authorized or managed by intellectual property law, which is concerned mainly with how innovation is created and provided with protection, not with how it is disseminated. For example, the patent system is generally characterized by a considerable degree of agency control over the decision to issue a patent, but relatively little control of what is done with patents after they are issued. Post-issuance enforcement practice is left largely to the courts. Further, the incentives to creating and managing these contractual devices are self-serving. As a result, the tools of antitrust are better for addressing both competition restraints and innovation restraints within the context of these arrangements. One very important role for antitrust in innovation-intensive markets lies in the vast area called the innovation commons, or where the production and dissemination of technology or information involves the joint activities of two or more persons. The literature on patent pools tend to accept as given that patents confer valuable property rights and then tries to explain both the benefits and competitive dangers of pooling. Significantly, patents are non-rivalrous, which means that one person's consumption of a patent by licensing does not reduce the amount that is left over for others. This provides a strong rationale for pooling because it entails that a product-improving technology can be shared across a large number of firms. The fact that patents are non-rivalrous also entails that restrictions on output must be scrutinized more carefully than output restrictions for rivalrous commons, such as fisheries or shared grazing rights. Each fish taken from a common pool reduces the number available to other fishermen. As a result, there is nothing suspicious about a rule in a commons for, say, giving grazing rights that limits each rancher up to 100 head of cattle. An output limitation in a patent pool must be examined more closely, however, because one firm's use of a patent does not limit the number of uses available to other members of the pool. Rather, the problem with patents is on the output side, rather than on the use side. Each sale of a patented good reduces by one the number of sales that are available to others in the pool. Antitrust policy generally views output limitations as bad, But patent pools present the problem that the shared assets are, for the most part, fixed costs. As a result, unrestrained competition among pool members in the market may drive prices so low that members may not be able to recover their investment. This may reduce pool members' incentive to innovate further. To be sure, antitrust has a rule of reason and an ancillary restraints doctrine for addressing this issue, but the rule of reason does not ask whether an output reduction and higher prices are needed to pay off the investment in patenting. Rather, it considers such questions as whether the patents in the pool are fundamentally complements or substitutes. Complements suggest integration, elimination of double marginalization, and thus higher output. Substitutes suggest the possibility of collusion. In both the Beament and General Electric cases, the Supreme Court upheld price fixes in cross-licensing agreements, mainly on the theory that a patent conferred a monopoly that the owner was entitled to share while keeping total output to the monopoly level. This reasoning is fallacious, however, to the extent that many patents are of dubious validity. It permits product collusion disguised as a patent license. However, the reasoning is also fallacious if the patents in question are perfectly valid, because it attributes the entire value of the cartel markup to the patents, something that is almost never the case. To give a simple example, suppose you patent a device that permits the digital display in a wristwatch to show its numbers in pink rather than the usual gray or orange. I patent a watch band that latches with a hook rather than a buckle. We are the only two watchmakers, and we pool our respective patents and fix the output price of watches from $10 to $20. The amount of this cartel markup very likely has almost nothing to do with the value of these patents, which add little to the value of our watches. The patents could be perfectly valid, but yet they have little or no value because few customers are willing to pay significantly more for the technologies that they offer. That leaves the problem of excessive competition in patent pools. Should product market restraints on output or price be justified because this is the only way that pool members can avoid ruinous competition? My answer is that while that problem may exist in the rare patent pool for a commodity, it very likely does not apply to markets for product differentiated goods. Manufacturers of digital cameras, smartphones, players of digital media, and numerous other users of patent pools produce distinctive products, which they sell at different price points and with different features. This means that each manufacturer faces a somewhat downward sloping demand curve. Prices will be above short-run marginal costs, and for the most part, the firms will be able to recover their fixed costs, including investments in patents or copyrights, without output restraints. One deficiency in the literature on patent pools is that it tends to accept as given that patents are valuable property rights and then devises explanations for why they are pooled. There is another important explanation, however, which is that patents in heavily pooled industries have little value in many cases, or in many cases, even negative value. For example, Besson and Moyer conclude that in most industries other than pharmaceuticals and chemicals, the private value of patents is less than the costs of obtaining them, keeping them up to date, and defending them in litigation. In these industries, which involve information technologies where a great deal of pooling occurs, pooling is simply a way of contracting out of a system that does the participants more harm than good. By pooling, they can produce their products free of the cost of infringement litigation among themselves. Nevertheless, pooling in order to neutralize the harmful effects of negative value patents represents an extreme social cost. First is the administrative costs of creating such patents and accumulating them in the first place. Second is the cost of forming and operating pools and defending members against threats from outside. However, antitrust is not a roving mandate to repair defects in a patent system, no matter how costly. Accepting the existing patent regime as given, however, antitrust can facilitate the kind of pooling arrangements that restore incentives to innovate and compete that the patent system has taken away. Exclusionary practices involving intellectual property rights generally provide a smaller role for antitrust than do collaborative practices because so much exclusion is determined by the IP laws themselves. Under the decisions of the Federal Circuit, the role of antitrust in policing patent exclusion is narrowing even further. For example, under the Supreme Court's Walker Process Doctrine, a patentee can violate Section 2 of the Sherman Act by filing an infringement suit on a patent that was procured by fraud, in that court's words, which generally means inequitable conduct or the making of false or misleading statements during the examination or patent prosecution process. Under the directions of the Federal Circuit, however, inequitable conduct has become extremely difficult to prove. In its 2011 Theracense decision, the court required actual subjective intent to deceive the PTO on a material issue. Even when inequitable conduct is found, however, the Federal Circuit has raised an extremely high bar for antitrust counterclaims. In its Dippin' Dots decision, for example, the patentee lied to the PTO about numerous sales that had occurred more than 1 year prior to the filing of its patent application. This made the technology unpatentable under patent law's on-sale bar. The court found clear evidence of intent to deceive and that the patent was unenforceable. Some 13 years later, the patentee filed an infringement suit at a time when evidence of prior sales would be extremely difficult to locate and discoverable as it was only by happenstance. Nevertheless, the Federal Circuit denied antitrust liability, holding that while a declaration of inequitable conduct required only a single improper act, the antitrust laws required at least 2 distinct acts. What the court overlooked is that even under its odd 2-act requirement, there were in fact 2 acts. The fact of the prior sales was enough to make the patent unenforceable, and the fact that the applicant denied about them was enough to create inequitable conduct. But in this case, the patentee had done not only that, it had also filed an infringement suit long after. The infringement suit, not the act of lying about prior sales, was the gist of the antitrust violation. The principal distinction between inequitable conduct and Walker Process-style antitrust cases is temporal. In general, inequitable conduct refers to actions and state of mind that occur during the patent prosecution process. By contrast, Walker Process refers to actions and state of mind at the time a patent infringement action is filed, which can be many years after issuance, roughly 12 years, for example, in the Dippin' Dots case. Or to state this differently, the doctrine of inequitable conduct governs the patent prosecution and issuance process largely during the pre-grant stage when PTO supervision is intense and there is little or no room for antitrust intervention. By contrast, antitrust liability under the Walker Process doctrine is intended to refer to enforcement activities during the post-grant stage when there is little to no PTO supervision. As a result, the Dippin' Dots rule needs to be re-examined. Finally is refusal to license, antitrust law's proverbial bad penny. Going all the way back to the Colgate Doctrine in 1919, United States antitrust has permitted dominant firms acting unilaterally to refuse to deal. One exception that the Supreme Court recognized in its 1985 Aspen decision is that a firm that has voluntarily established a course of dealing may not withdraw from that venture without a good explanation. More recently, however, in its Trinco and Linkline decisions, the Supreme Court has reverted to formulations that leave very little space for unilateral dealing obligations. But there's one very important difference between refusals to license patents and refusals to deal generally. In the ordinary case, the refused rival must either build the refused asset for itself or else seek it from a different source. For example, if I refuse to share my gas pipeline with you, you must either build your own pipeline or else seek transportation space on someone else's pipeline. Indeed, one of the objections to antitrust essential facilities doctrine is that it forces firms to share assets in public utility fashion rather than giving rivals a competitive incentive to develop these assets on their own. In the case of patents, however, a firm who's been denied a patent license from another does not have the option of building any technology on its own if that technology infringes the other's patent. Indeed, it will not be able to build infringing technology even if it does not know about the other's patent, as is apparently the case for most patent infringers. To be sure, it might be able to invent around the dominant firm's patents, but inventing around can be a very risky proposition if it requires a large upfront investment. Finally, the no duty to license rule applies even when the dominant firm's patent is not being used, and indeed even if the dominant firm acquired it from another for no other purpose than to shut it down and to deny to rivals the technology that it offered. One partial solution is to permit firms with significant market shares in the product market to acquire only non-exclusive licenses in patents developed by outsiders. That would be an antitrust solution, not a Patent Act solution, but it is not inconsistent with the Patent Act either. To be sure, the Patent Act permits both the assignment of patents and the granting of exclusive licenses, but that grant does no more than provide that the patent should be treated just as other forms of personal property, which means they can be freely transferred, provided that the transfer is not unlawful on other grounds. To conclude then, the field of IP antitrust has blossomed in the last 2 decades and has become a significant component of antitrust practice today, producing a treatise literature as well as law school classes and case books. The fact is that managing competition for innovation is a complex task, made more complex and difficult by deficient intellectual property policies. Although courts are not perfect institutions either, there's a lesson to be learned here. We would probably have a better and more defensible intellectual property system if we had left somewhat more to the courts and less to the statutes. To be sure, antitrust policy has also veered all over the place, for large parts of its history protecting competitors more than consumers. But this was less a function of special interest capture than of lack of economic sophistication and serious ambiguity about antitrust's underlying goals. In the last 30 years, just as antitrust has become more responsive to concerns for preserving economic competition and consumer welfare, the IP laws have unfortunately gone in the opposite direction, protecting rights holders at the expense of the progress of science and the useful arts that would benefit consumers. Thank you.
We have time for questions.
Yes, sir. Bert. I think so. EU antitrust policy, Eleanor knows much more about this than I do, but EU antitrust policy up till now has been more protective of anti-competitive assertions of patent rights than US law has. I'll just venture this, that I think it was a mistake for the Federal Circuit to start making its own antitrust law in patent cases. That was a choice. That was not mandated by the statute. And the unfortunate result from where I stand is we have a set of patent rules that grant way too many patents and provide way too many incentives for over-enforcement. And the Federal Circuit's also bending over backwards to reduce the impact of the antitrust laws in litigation that involves patent rights. In my view, that means that they're taking the most deficient of these two systems, the one that's been most responsive to special interests, and giving it broad interpretation, and taking antitrust, which I believe is a far healthier enterprise today than it was 30 years ago. I'm waiting for you to scream at me. And I think that's a bad outcome. I believe that the world would be a better place if the regional circuits continued to address the antitrust portion of antitrust patent law complaints. Yes, sir. I'm sorry? In some markets, yes. I think blanket licensing of media, performance rights in music, for example, is a wonderful thing. I think it was a good solution to that problem. I don't think it has produced very many real problems other than setting some mandatory fees and a few things like that. Patent pools and information technologies are a much more diverse and complicated phenomenon. I mean, first of all, the sheer numbers of these patents is astonishing. You know, we talk about pools that involve, in some cases, Intellectual Ventures is reputed to own 60,000 patents. Well, those of you who are involved in patent examination for patent litigation know that examining just one patent for possible infringement, that is going through claim construction plus examining the alleged infringer's technology, can cost several tens of thousands of dollars. And in many of these cases, the real value of the patent pools in many information technologies is nothing that the innovation incentivizing structures of the patents themselves provide, but rather in the extraordinarily high transaction costs they impose. And as a result, we are spending an extraordinary amount of resources creating, moving around, and defending against a lot of patents on things for which the particular firms, now I'm not talking about pharmaceutical companies, I'm talking about firms like Micron and Apple and others who make informational systems and electronic devices. Most of them regard patents as very little more than a costly headache. They get them for strategic reasons, not really to promote innovation at all. And there's very little reason to believe that we would have less innovation in those markets if we did not have such broad patent protection. So I think there is a problem there, and I think it's going to get more serious. Yes? It might. The only answer I can give to that is that neither IP nor antitrust creates a right to create market monopolies. And so you don't have a right to sell your asset into a monopolized market simply because it's worth more there. But yes, it may have that kind of right. I haven't seen any studies that have reflected it yet. Yes? Well, I think your question raises two issues. First is, should software be patentable subject matter to begin with? And secondly, should there be limitations on disclosure with respect to software that don't apply to other patents? I'm kind of agnostic on that first one, but I tend to agree, I think, with the gist of your comment that the goal of the patent system, you know, you don't have this problem with copyright because the duration of copyright is so long that any piece of software you make today is going to be obsolete by the time its copyright expires. But to the extent that the goal of the patent system is disclosure and the availability of the patent as a recipe so that it enters the public domain, failure to disclose the source code frustrates that. And as a result, I think a good case can be made that one of the choices a software developer must make at the time it decides whether to seek patent protection, because patent protection isn't essential for most uses, copyright protection is fine, but one of the choices they could appropriately be asked to make is to reveal their source code. I mean, the question needs to be, the question may not relate to revelation of all of the source code per se, but the question needs to be, has this piece of technology truly entered the public domain with sufficient specification that an outside reader of that patent can employ it? And if the answer to that question is no, then that patent is lacking in the disclosure requirements that patent law requires. Yes? Well, what I suggested is that intellectual property holders in general be required to show that the infringement at issue undermined the incentive to innovate, okay? That's a different question in patents than it is in copyrights. But even in IP law, there are a lot of different issues. One has to do with unused patents. Should firms be entitled to injunctions with respect to unpracticed patents? There, I think you want to divide the territory between firms that are practicing some patents and other firms that are not practicing any patents whatsoever. It shows up very distinctly in the breadth of the doctrine of equivalence. How wide a range are we going to permit a patent to protect? It shows up in what I regard as an excessively liberal policy with respect to patent continuations, right? The claims that a patentee, a patent applicant, drafts in its original patent application are the best indicator of what its foresight was. Remember, the patent, you always look forward from an ex-ante position. What did I develop as my invention? And as a result, what can I be meaningfully be said to rightfully exclude? Well, if I'm permitted to draft late claims under Fed Circuit law, you can even observe your rival's newly developed technologies. Your patent application hasn't been published yet. You can observe rivals' independently developed technologies, and you can write claims on that technology. That's what Rambus did in the 1990s, and get retroactive application, okay? Well, those late claims do nothing whatsoever to incentivize one's own innovation. They simply capture the innovations of others and internalize them to your own patent. So there are different things patent law can do. Christina and I just published a book called Creation Without Restraint. I'll put in a little ad for it here. Oh, thank you, Carol. Carol's going to show it to you.
It exists, here it is.
In which we address a number of these issues and make some suggestions for how patent law can be aligned more properly with the incentive to innovate. Any antitrust questions here? Is this an antitrust lecture, isn't it? Anybody? Okay, well, thank you very much. I'm very flattered to be asked.